The 5-year rule allows the government to potentially claim your house. And most seniors do not discover this until it becomes too late to take action. If you are 65 or older, if you own your home, if you have any savings whatsoever, you need to understand exactly how this rule functions, because the professionals who should explain it to you have a very strong incentive to remain silent. There is one specific document that can prevent the entire process before it starts. But most estate attorneys will not mention it unless you request it specifically by name. I will tell you what that document is called before this video ends. The rule itself is called the Medicaid 5-year lookback, but the name is deceptive. It is not really about reviewing the past. It is about applying consequences for actions you took when you did not realize you were doing anything incorrect. Here is how it operates. If you ever require long-term nursing home care, and the average stay in this country now costs over $18,000 per year, you will almost certainly deplete your funds. Therefore, you will have to apply for Medicaid to cover the expense. But before Medicaid pays a single dollar, a state caseworker will examine every bank statement, every property record, and every gift you have made for the previous 60 months. Every single transaction, every check to a grandchild, every vehicle you transferred, every dollar you moved. Then they determine a penalty. The penalty is not a fine. It is something far more serious. The state takes the total amount you transferred during those 60 months, divides it by what they call the regional penalty divisor, which in most states falls between $10,000 and $12,000. And the result is the number of months you are prohibited from Medicaid coverage. During those months, you must pay for the nursing home yourself at over $9,000 per month, even though the entire reason you applied for Medicaid is that you do not have $9,000 per month. This is the problem. You gave away the money. Therefore, you cannot afford it. But because you gave away the money, the state will not pay either. So, who pays the nursing home? The nursing home does not care. They will pursue legal action. And the first asset they will target is your house. Most people believe the rule only catches large transfers. That is incorrect. The look back catches everything. A $400 Christmas check to your granddaughter counts. Paying for your son's wedding counts. Helping a grandchild with college tuition counts. Forgiving a loan to a family member counts. Selling your car to your nephew for $1 counts. Even charitable donations above a certain threshold can count depending on the state. There is no birthday exemption. There is no holiday exemption. There is no I did not know exemption. The federal annual gift tax exclusion, which clears throat currently sits at $19,000 per recipient, has nothing to do with this. That is an IRS rule. Medicaid is a completely different system with its own rules, and Medicaid does not care what the IRS allows. A gift that is perfectly legal under federal tax law can still trigger a full Medicaid penalty. Most seniors do not understand this distinction. Therefore, they assume their gifts are safe. They are not. Now, here is where it gets more difficult, and this is the part that creates conflict in families for years to come. If you are married and your spouse enters a nursing home, you might think the law protects the healthy spouse who remains at home. There is a protection. It is called the Community Spouse Resource Allowance. And in 2026, it sits at $157,920. That is the maximum amount of countable assets the at-home spouse is allowed to keep. Everything above that number must be spent down before Medicaid will pay 1 cent. $157,000 sounds like a lot until you realize what it actually has to cover. Property taxes, home repairs, Medicare premiums, food, gas, medications, emergencies for the rest of the healthy spouse's life, which could be 20 years, which works out to roughly $657 per month. That is the math the state expects you to live on while your husband or wife is in a facility that is charging over $9,000 per month for the same time period. But the house, surely the house is protected. The house is the one thing they cannot touch. That is what almost every senior in America believes, and it is incorrect. The house is exempt while you are living and occupying it. Therefore, Medicaid will not require you to sell it before you qualify. But the moment the Medicaid recipient passes away, a program called the Medicaid Estate Recovery Program becomes active. Federal law requires every state to attempt to recover the cost of care from the estate of any Medicaid beneficiary who was over 55 at the time benefits were paid. The recovery target is the house. The state files a claim against the estate. The heirs are told they must either pay the bill in full, often hundreds of thousands of dollars, or sell the home and turn over the proceeds. The average estate recovery claim in this country now exceeds $74,000. In some states, it is over $200,000, and it is not optional. It is not negotiable. The federal government requires the state to come after the house. Therefore, the house your parents promised would go to the grandchildren ends up going to the state of whatever they happen to live in. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an even older law in the books called filial responsibility. These laws say that adult children can be held financially responsible for the unpaid nursing home bills of their parents. For decades, these laws sat unused, but starting in 2012, after a Pennsylvania appeals court ruled that a nursing home could collect $93,000 from an adult son for his mother's care, the situation changed significantly. Therefore, the trap is not just that the state takes your house. The trap is that the nursing home, after the state finishes its recovery, can turn around and pursue your children for whatever is left. I will give you a real example. A widow in Ohio, age 78, transferred $45,000 to her daughter over a 4-year period. Birthday gifts, holiday checks, some help with a car repair. Nothing she considered unusual. She entered a nursing home in month 47 of those 4 years. The state divided her $45,000 by the Ohio penalty divisor of $7,163 per month and locked her out of Medicaid for 6 months. The nursing home billed her $9,200 per month for those 6 months. Total bill $55,200. She did not have it. The home placed a lien against her house. She passed away 8 months later. The state then filed an estate recovery claim for an additional $140,000 in care costs. Her daughter received a letter informing her that the home she grew up in was being sold by court order. There is a strategy that some attorneys use to reduce the damage when there is no time left. They call it the half a loaf. The idea is that if you or your spouse already requires care, you give away half of your remaining assets and use the other half to pay for care during the penalty period that the gift triggers. It saves something. It is better than losing everything, but it requires careful timing. It requires a specialized attorney, and it has to be done before the Medicaid application is filed, not after. Once you apply, the strategy is finished. The seniors who lose everything are almost never the ones who plan. They're the ones who were never told planning was an option. They sat in a hospital room, signed a power of attorney, and started writing checks to the nursing home with no idea that with one phone call to the right kind of lawyer 2 years earlier, they could have protected the house, the savings, and the inheritance. Now, I told you at the start that there is one document most estate attorneys will not bring up unless you ask for it. Here's what it is called. It is called a Medicaid Asset Protection Trust in 5 specific states, including Florida, Texas, Michigan, West Virginia, and Vermont. There is also something called a ladybird deed, which accomplishes part of the same goal for the home. Specifically, a Medicaid Asset Protection Trust is an irrevocable trust. You move your house, your savings, and your investments into the trust. You no longer technically own them. The trust does, but you can still live in the house. You can still receive the income from the investments. You just cannot withdraw the assets back out after the trust has been in place for 5 years. Those assets are no longer counted by Medicaid. The lookback cannot reach them. The estate recovery program cannot reach them. The house is protected. The savings are protected. Everything inside the trust passes directly to your heirs without going through probate, without going through estate recovery, and without being touched by the state. The reason most attorneys do not mention this is straightforward. A Medicaid Asset Protection Trust costs between $4,000 and $12,000 to set up correctly. A standard will cost $200. The senior walks in asking for a will. The attorney sells them a will. And the conversation about long-term care never happens. Therefore, you must walk in already knowing the right phrase. You must say the words Medicaid Asset Protection Trust out loud. And you must ask whether you qualify, and you must do it at least 60 months before any care is needed, because the 5-year clock does not start until the trust is funded. Here is what to do this week. First, pull every bank statement from the last 60 months and look for any transfer over $500 to a family member. Make a list. You need to know your exposure before you talk to anyone. Second, find an attorney who is certified in elder law specifically. The certification is called CELA, which stands for Certified Elder Law Attorney. A general estate attorney is not enough. You need someone whose entire practice is built around Medicaid planning. Third, ask that attorney by name about a Medicaid Asset Protection Trust. And if you live in Florida, Texas, Michigan, West Virginia, or Vermont, also ask about a ladybird deed for the home. Fourth, get the trust funded right away because every day you wait is a day added to the back end of your 5-year clock. Fifth, tell every adult child in your family to read this exact same information because the rule does not just affect you. It affects everything you plan to leave behind. The 5-year clock starts the day the trust is funded, not the day you decide to plan, not the day you call the lawyer, the day the assets actually move. Therefore, the most expensive day in your life is the day after you should have started,